919 words within target range. Here's the script. There is a doctrine called the sole executive agreement. It appears in no law you've read, no bill passed either chamber, no amendment ratified by the states, and yet it has existed since 1937 when the Supreme Court declared it binding. It lets one person, the president, commit the United States to the terms of a foreign government with a signature. No Senate vote, no House vote, and once it's made, no court in the land has ever undone one. Here is what it actually is, stripped of the legal language. A treaty needs 2/3 of the Senate. That's in the Constitution, plain as day, Article 2. But somewhere along the way, presidents started making a different kind of deal, not a treaty, just an agreement. And courts decided an agreement carries the same force of law as a treaty, minus the vote, minus the debate, minus the record. It can preempt state statutes. It can override state courts. It can settle claims involving your property, your bank account, your inheritance, and you would never know the mechanism existed until it reached into your life and rearranged what belonged to you. It came into being the way most permanent power does, quietly, through a case nobody outside a courtroom was watching. In 1933, Franklin Roosevelt recognized the Soviet Union. As part of that recognition, he signed something called the Litvinov Assignment, transferring to the U.S. government all claims the Soviets held against American companies and individuals, money, seized assets, frozen accounts, decades of frozen disputes. He never asked the Senate. He didn't need a treaty, he said, because this was merely an agreement. In 1937, in United States versus Belmont, the Supreme Court agreed with him. In 1942, in United States versus Pink, it agreed again. A private arrangement between two executives had become the supreme law of the land. Today, that power doesn't sit with one president. It sits with the office itself, inherited case by case for 90 years, expanding every time a court declined to draw a line back. State Department lawyers control which international commitments get called agreements instead of treaties, a label they choose quietly in a memo you will never see with no public hearing and no public record of the deliberation. That labeling decision is the entire ballgame. Call it a treaty and the Senate gets a vote. Call it an agreement and the Senate gets nothing, and neither do you. Here is where it stops being abstract. In the Belmont and Pink cases, the actual dispute was money, a Russian insurance company's assets, held in a New York bank, belonging to depositors and creditors under New York state law. The Soviet government had nationalized that company and claimed its funds. Roosevelt's agreement said, those claims now belong to the United States. New York courts said the seizure violated state public policy and refused to honor it, ordinary state law, doing exactly what it was designed to do, protecting people who had deposited money in good faith. The Supreme Court overruled New York anyway. Ordinary depositors, people who had never heard of executive agreements, who had simply put money in a bank, lost their legal claim to it, because a foreign policy handshake outranked their state's property law. That is the doctrine's real teeth. It can reach past your local courts, past your state legislature, into a private account, and settle the matter before you are ever allowed to argue it in front of a judge. And here's the part that should actually worry you: none of this was a violation. It's completely legal. No one broke a rule making this. The Constitution never mentions executive agreements at all, not once in any clause. The Supreme Court simply reasoned that the president's power to conduct foreign relations includes the power to settle claims and recognize governments, and that settling claims sometimes requires binding Americans to the outcome whether they agreed to it or not. Nothing in that reasoning has an expiration date, and nothing in it requires a vote ever again. Remember, no one voted for this. Not in 1937, not since. And it cannot be repealed the way a statute can, because Congress never passed it in the first place. There is nothing on the books to strike down. You cannot repeal a Supreme Court's interpretation of inherent presidential power with a bill. You would need the court itself to reverse 80 years of its own precedent. Against a doctrine it has only ever expanded, never narrowed. Every subsequent case, Dames and more in 1981, the Iran hostage settlements, sanctions, and asset freezes since cited Belmont and Pink as settled law, never questioned it. The lock isn't a law. The lock is a habit of deference, repeated by courts until it hardened into something structural, which means the real story here isn't about executive agreements at all. It's about how much of what governs you was never voted on by anyone, decided instead in a courtroom, described as an application of existing power rather than the creation of new power, and therefore never subject to repeal, review, or a ballot. If this much authority can exist through a single case in 1937, entirely by inference, from 3 words in Article 2, the question worth sitting with is how many other doctrines like it are already operating quietly beneath the ones you were taught to watch.